Hi everybody, welcome back to 10 Minutes with Griffin. I'm your host, Griffin Bridgers. For today's episode 156, we're going to tell you why you should not get rid of that trust. I emphasize that because this is a recurring theme I see, and one of the most frustrating things you see as an estate planning attorney is a situation where a client or advisor has gotten rid of that trust without talking to you first. Now, as always, this presentation is not intended to substitute for legal or tax advice and is provided for educational purposes only. If you'd like a copy of these slides, please email me at griffin.bridgers@gmail.com. Now, this is a common exchange I see that happens between a client and their financial advisor or CPA. And the theme of this exchange is that we're reviewing the estate plan in general and all the documents and trusts in place. What the advisor or CPA says is, this irrevocable trust complicates your life, mainly by generating an extra Form 1041 instead of K1s each year. What if we just terminate the trust and distribute the assets to you? Now, this is often done with good intentions. You want to simplify the client's life and you want to be a hero to your client, but you're not being a hero when you do this. This could create extra liability exposure for your client in multiple areas and maybe even for you. And we're going to see why. That trust is not just there to aggravate people. Now, this is a common misconception that clients look at trusts and view them as an impediment and a complication. In other words, it's, the trust has the word, trust as a common theme, but clients often view them as an element of distrust. And there's a lot of baggage that goes with that, in terms of family dynamics and everything. But there's one big benefit of a trust that people often ignore, and that's asset protection. Now, there's so many layers to asset protection that there is no way I can really fully do it justice here. But I want to draw a couple broad themes here with broad strokes to show you what I mean. To start with, in many states, you can't put your own assets into an irrevocable trust and shield those assets from your own personal creditors. That type of trust is known as a self-settled trust. Now, there's a handful of states where you can do that, but in most states, that's the norm, is that you cannot create that type of trust and it's void. But if you go the other way, if you have a trust that's created for you by somebody else, it is really, really easy for them to create asset protection for you in that trust as a beneficiary. Likewise, if you're creating a trust for somebody else, it's easy to create asset protection for them if you're the grantor of that trust, the creator. And that asset protection stays in place as long as the beneficiary does not touch the trust. Leave it alone. Leave those assets in there until you need them, because the minute they hit your personal account, that asset protection is gone. So you can imagine that could happen in a case where there's just a simple distribution, or in a case where you terminate the trust and distribute everything to the beneficiaries. And the bad news is that once the assets are out of the trust, you can't put them back in. You can't get that asset protection back because trying to put it back in makes it a self-settled trust. It's like trying to put toothpaste back into the tube. You just can't do that once the toothpaste is out. So the trade-off here is, what's worth more? Do you want to protect your trust assets from the claims of your creditors, or do you want to save a few $100s per year in tax filings? Now, we live in an attention-starved society where a lot of people just look at the short term and the quick fix and say, we'll choose the latter because, who doesn't want to save money? It's easy to put that on paper and have an advisor or CPA look like a hero to their client by saying, hey, look at how much money we're saving here. And it also looks at an abstract theory that clients often don't recognize, that bad things could happen to them. They don't want to think about that. But one simple fender bender could mean a loss of the trust assets once they're out of the trust. You can't put the toothpaste back in the tube. Once it's out, it's potentially wasted. So with that being said, when your client is the only beneficiary of the trust right now, this seems safe to do if you're the advisor saying, hey, let's do away with this. But It ignores the fact that most irrevocable trusts have remainder beneficiaries and they cannot be ignored. Now, to terminate a trust, you have to go to the trustee and get permission to do so. And sometimes the trustee will be your client. They're both trustee and beneficiary, but that doesn't give them carte blanche to just raid the trust and terminate it and title those assets into their own individual names, because the trustee has fiduciary duties. They have to balance their own needs with the needs of the remainder beneficiaries. And in the worst case, that could lead the remainder beneficiaries down the road, when this is discovered, to sue the trustee who might be your client, or the client's estate upon death when it's discovered that there's been a breach of the trust. And yeah, there's statutes of limitations, but those usually only apply from the time that the remainder beneficiaries knew or could have known of a breach of the trust. So sometimes they won't know until all of a sudden there's a death and there's nothing left for them. So you don't avoid liability by doing this. And in fact, if you're advising to terminate the trust, this liability could come back to you as the advisor or CPA if it's shown that you advised to terminate the trust as well. So you don't want to end up in that sort of a situation. Now, some of you are saying, but wait. I read the trust. It says that the trustee can terminate the trust if it becomes uneconomical to administer. I also Googled it, and local law says that I can do so too. My state has adopted the Uniform Trust Code. And it's true, that's often the case, but that doesn't give the trustee carte blanche to terminate a trust. You have to show how it was uneconomical to administer the trust, usually by showing that the trust has been drained to a certain dollar value, usually below $50,000. That's not a safe harbor by any means. And if the income of the trust far exceeds the tax filing cost, it's likely not going to be the case that it was uneconomical to administer. Paying a few $100s to prepare a trust income tax return does not make it uneconomical to administer a trust. And likewise, income rate disparity is likely not a compelling reason to terminate a trust either, mainly because you can remove some of that disparity simply by terminating income of the trust to the beneficiary instead of just terminating everything in the trust. Yeah, you have to do a K1 and a 1041, but you would have had to do that anyway. So, the big takeaway here is just to think twice before advising a client to terminate an irrevocable trust. Even if the client's a trustee, even if the language authorizes it, and even if it doesn't seem like there's any descendants who are remainder beneficiaries. And I'm not saying that this is a black and white issue. More often than not, it's a good idea to leave the trust alone until it's needed. But there could be cases where, yes, it does make sense to terminate the trust. And I'm not here to say that you absolutely should never terminate the trust. But what I am saying is that if you decide to go that route, don't just say, hey, this is a good idea. It's a good idea to paper the deal. For one, you want to show how it was uneconomical to keep the trust intact versus just distributing the asset out, or the assets out. You might also want to look at having some sort of agreement where you get consents and releases from the remainder beneficiaries so they don't come back and sue for a breach of fiduciary duty down the road. And even then, getting consents and releases from the living remainder beneficiaries may not be enough under the virtual representation rules we have under the Uniform Trust Code. But that's a subject for another time. And if you're an advisor, this doesn't just protect the client, it protects you from personal liability. And this is going to be important in the future because we're going to see a lot more trusts coming down the road as wealth passes to the next generation in trust instead of passing outright. So you're going to see a lot of irrevocable trusts, and you're going to see a lot of clients who say, oh, I wish I didn't have this. But there's a lot more benefit to be gained from leaving it alone until you need it than there is to just saying, hey, let's get rid of it so I have less paperwork in my life. Because less paperwork equals much more paperwork down the road if you have a simple event that leads to liability. As always, if you have questions or topic suggestions, you can email those to me at griffin.bridgers@gmail.com. But thank you for listening to this episode of 10 Minutes with Griffin, and I look forward to seeing you in the next one.